Hi, everyone. So sorry about that technical problems earlier. It's really frustrating, mostly because I was looking forward to seeing you and seeing how you're doing and making sure everybody's okay in the kind of smokiness. So I want to do this very quick PowerPoint about citation first and then case briefing. It really relates to what we talked about last class, but it kind of breaks it down a little bit more, and I wanted to um, make sure to provide that for you. A couple of housekeeping things. One, the citation exercises. So those appear to be graded on Canvas. They're not. So my aim in giving you those exercises is really to just help you get some foundation around citation. I do not um, intend to grade them. They are to help you sort of develop the habits around citation. But here's an important thing. I don't expect you to memorize the citation rules. I want you to know how to find them. Eventually they'll become habit and you won't need to look at them up every time, but I don't expect that to happen now. So number one, not graded. Number two, use the book. Grammar and punctuation. So on that, there's a little issue with Canvas in that it's supposed to let you have 2 tries and it's only letting you have 1. I'm going to see if I can fix that. In the meantime, if you people have been great about sending me emails, letting me know that that's a problem, and I will continue to respond to those. On grammar and punctuation, here's the other message similar to citation. I am completely fine with you using the book. In fact, I want you to. So as you are taking those quizzes, have the legal writing handbook right there and open and double check yourself. You look for the answer. This, again, it is far more important to me that you know how to find the answer than that you have it memorized from either from the slideshow or from some past experience. Okay, so there you go. That's the housekeeping. Okay, so let's get to it. First, the result of the poll. So question 1, I asked you if there's any case you wished I had included. And so we have, majority of people saying, nope, I'm good, 4 is good. And we've got about 30% saying they would love to have been able to use Voltava. So let me just say again, you can. Go ahead and if you want to use Voltava, you can. You don't have to. Indeed, you don't have to use all of the 4 cases I gave you. But Voltava has some interesting facts. Now remember that our issue is not about the affirmative defense. It's about whether the element of actual physical control has been met, and that burden is held by the state. Okay, so number 2, which of these general rules is contained in the Smelter case? So last class I had you do some work where you were trying to extract those general rules from Smelter, and so you could choose more than one, and then more than one is correct here. So right, the liberal construction of the rules prohibiting driving while intoxicated, yes, that's a general rule. It applies to the statute as a whole, and it's helpful to the reader to orient themselves to what will ultimately be a much more narrow issue. The burden of proof rests upon the state. The other classic thing that's in the general rules, burden of proof. Positioning in the driver's seat is an element common to all cases that have found actual physical control. So that is a rule related to the element of actual physical control, not a general rule, but a specific rule. So that is not among the general rules. Yep, actual physical control is the broadest of the 3 potential DUI charges. Yes, that's a general rule applicable to the whole statute. Purpose of the statute is to deter intoxicated people from getting into their cars. Yep, again, that applies to the statute as a whole and not to the particular element of actual physical control. And no Washington case or statute defines actual physical control. So this was a kind of a trick. It is both a rule that appears to be related to actual physical control as an element, but it's also not really a rule. It's just the court kind of introducing, saying Smelter court introducing, saying no one's decided this yet, and then Smelter decides it. So it's probably not a rule that's going to be useful to your, or a statement that's going to be useful to your reader. And I wish I had you right here with me so that you could ask me questions about this, but jot them down and then bring them to class on Thursday. Okay, more results of the poll. Oh, I'm going to sneak back again. Okay, I'm going to move to number 3. Yes. So here, number 3 asked you, which of these is a rule from Smelter related, pardon the typo, related to actual physical control element, meaning the specific, which of these is a specific rule related to our disputed element? So no Washington case defines actual physical control, right? Same trick. It's not really a rule. I suppose it's more related to this element, but not really a rule. Second, yes, everybody got this. Yes, this is one of the 2 big interpretation type rules that Smelter announces. The focus shouldn't be on the condition of the car, but the status of the occupant and the nature of the authority he or she exerted over the vehicle. Yep, that's a specific rule related to this element of control. Second, whereas here circumstantial evidence permits a legitimate inference that the car was where it was and was performing as it was because of defendant's choice. Again, that is a rule related to actual physical control. So that's a specific rule. This last one was a trick. Actual physical control requires active or constructive possession of the key. So if this was a rule that Smelter announced, it would be a specific rule. But actually, this is a rule from a case from Alabama, right? The Smelter court doesn't explicitly adopt it. The Smelter court sort of goes through a bunch of other state decisions. This is one. So that was a trick question. Again, jot down your questions. We can talk about them. Question 4, why do we care about Sunnyside versus Went? This was a case I gave you, new one. And the question here really is Went useful because the court interprets the actual physical control, or because of how it applies it to facts? You got this overwhelmingly correct. It's useful because of how it applies the rule to the facts. It will be useful as an analogy. Excellent. Okay, that's it. Okay, so let's talk citation for a minute. So what I wanted to ask you, if I had you all in the room, is to think about citation as communication. Think about citation as writing, because it is. And so I wanted to start by asking you about audience and purpose, which is where we start with any piece of writing. So who is the audience, and what are we trying to achieve with this piece of communication? So your audience is your legal reader. So for Memo 1, your audience is me. You know that I understand citation, I know the format, and I expect the format. And then the purpose of legal citation is to alert the reader to the fact of authority, meaning that this proposition, this isn't just me saying it, this is a rule that a court has announced or approved, right? It also communicates credibility in the proposition. That is, I guess it's another way of saying the same thing, right? I didn't make this up. This comes from a case. The other purpose is in case your reader wants to go find that section of the case, that case as a whole, and also the particular place where you found this rule. Okay, so there's your audience and purpose for citation. And I want you to think about citation as communicating those things. All right. So the source for the format of legal citation in Washington, so always be thinking about 2 things for our purposes. The Blue Book, which you've started to look at, and you're starting to read the Blue Book Uncovered, and also the Washington style sheet. Now this is pretty small. I'm just intending to give you a visual of what the style sheet looks like. It's really a PDF document, a paper document, that the Supreme Court has put together to guide the judges in Washington on the conventions that should be adhered to in their decisions. And so it is equally applied by those judges then to advocates appearing before them in their briefing. And so what the style sheet does is say, the Blue Book is our guide, except in some circumstances. So here in the general provisions, it says the Blue Book is what we use. The Chicago Manual is what we use, except, right? We use different abbreviations sometimes for certain things, and there are many listed particular exceptions to the Blue Book. The one you're going to run into the most frequently is that the Blue Book calls in briefing for the citation parties' names, Smith versus Jones, to be underlined. The style sheet calls for them to be italicized. So in Washington, we use italics. Okay, so here, just to give you the big picture view, here are some sample citations appropriate to Washington. That is to say, they combine the Blue Book with the style sheet. So here we have the statutory citation, right? RCW 19 title, 86 chapter, 020 section, right? And then next we have a case citation. So here we have parties' names, italics, comma, volume, reporter, page number, first page of the case, pinpoint site, we'll talk about that in a second, parallel reporter, and year. All right, so I'm going to break that down. But first, I want you to take out your Blue Book. You might want to pause me here while you get your Blue Book. So I want you to hold it in your hand and look at these different places. Just make sure you can find them. So the first really useful spot in the Blue Book are the covers. If you open up the front cover, you see behind it are a list of sample citations appropriate, I think, to academic articles. On the back cover, you'll see sample citations appropriate to briefing. The briefing citations will be useful to you in the work we'll do together, and the front cover academic citations will be useful to you if you're on law review. Next, I want you to find the blue pages. They are quite literally blue. They're light blue. And these are sort of the easy reference rules for non-academic writers. So it's a somewhat quicker way to find the particular rules of citation. The next place I want you to look are the white pages. They are white, and they contain the rules themselves, right? So the full statement of the rules, for example, about how to cite cases in the white pages. The Blue Book will sometimes refer you to tables that, among other things, tell you how to abbreviate parties' names, tell you the appropriate state by state and jurisdiction by jurisdiction citation for things like statutes or case reporters. And so those tables are in the section, a variety of sections called T1, T2, T3. So you'll see those there. There is no way to memorize all of the information in the tables or in the white pages or even in the blue pages. So it is most important that you're able to find things. So finally, the index. Use the index. It makes life easy. It's pretty easy to use, right? If you're looking for case citation, look under cases, right? If you're looking for Washington statutes, look under statutes or Washington. Okay, so there's the Blue Book, big picture intro. So I'm going to start with case citation, and then we're going to talk a little about statutory citation. So this is right out of Rule 10 in the Blue Book. I start by just giving you a complete citation and breaking it down into into pieces. Each of those pieces will have an associated rule or rules. So the first piece is the first party's name. So one rule you might be wondering about, well, who goes first? Is it always the plaintiff first? And the answer is in the Blue Book. And the answer is not necessarily. It depends in the particular jurisdiction whether or not the appellant, if the appellant is the defendant, that name sometimes goes first. So there's a rule about that. And you'll notice there's a word abbreviated, SAV period, which is the Blue Book's abbreviation for savings. So one of those tables is devoted entirely to Blue Book approved abbreviations. The V stands for versus. It's the abbreviation that separates the first party from the second party. So then you have the name of the second party. There's a comma, and then the volume number of the first reporter, which in our case will always be the official reporter. So the volume number is that number on the spine of the binder. It's the cases that were bound together. It is less relevant, of course, when in purely electronic research, but it is a way to find this case. So volume number first, reporter number second. You'll see that here this is a Supreme Court case, so the United States reporter is the reporter listed. And then you'll see the first page of the case, the page number where this case begins, and then comma, the specific page where the rule is found, the rule that you just described in the sentence before, and then the date of the decision. So those are the major elements of a case citation. Each of those will have some picky rules associated with it. In the Blue Book, in Rule 10, it gives you a nice breakdown of where you find those rules. So all the rules related to case names, 10.2, like who goes first, that'll be in 10.2. The rules related to reporters in 10.3. And you might see an associated table of how to abbreviate particular reporters. Courts and jurisdiction, rules 10.4, etc. Don't worry yet about parenthetical information or prior and subsequent history. We're going to talk about that related to Memo 2. So we'll come back to that. So I'm going to introduce you to one table that is particularly important for state court citation. So we're going to look at Table 1.3. So those are the U.S. jurisdictions broken down into states and D.C. So if you click through, I have Blue Book online, so I can click through. If you go to that table, then you'll see this or something similar, a whole list of states, and where you're going to find the information for us, you're going to go to Washington. So, and there, the Blue Book will tell you what the reporters are and how they are abbreviated. So you can see, for example, the Supreme Court's decisions are contained in potentially 3 places. One is the Pacific Reporter. We've talked about that as the unofficial parallel reporter. Now, the Blue Book says you should cite to P second, or P third if the case is there. So that's the Blue Book's rule, giving you the option then to cite to Washington reports, which is Wash or Wash second, according to the Blue Book. You will see that this rule is, this is one of the exceptions in the style sheet. So I think I go there next. Oh, good. So here is the exception, right? The Washington Supreme Court wants us to cite official reporters and regional reporters. So not just the regional reporter. And they want us to make the pinpoint cite, that's the particular page where the information is found, only to the official reporter. All right. What else? Right? Case name should always be italicized. The style sheet also gives us a different set of abbreviations than the Blue Book. So here are Washington reports, Washington appellate reports, and you can see that whereas the very old cases are going to be contained in the first series of Washington reports, which you may cite as WASH, W-A-S-H, period. But the vast majority of cases you will work with will be in the second series of Washington reports, and the court wants us to cite those as WN period 2D, no space between those two. Likewise, Washington appellate reports, WN period space APP, WN period space APP second. Okay, so picky. Okay, so here is the anatomy of a case citation when you put those two things together, Blue Book plus style sheet. Okay, first thing you see is a signal. So a signal it tells the reader how important is this case and how should I read it. So if one possible signal is the absence of a signal. And what that means to the reader is the proposition I just stated is directly supported by this case. If I used a C signal, it would suggest that the proposition I just stated, it can be inferred from this case. It is not directly stated, but can be inferred. So for Memo 1, you will not use any signal except the absence of a signal. Every case will just be a citation. Okay. Next thing, case name, party versus party, right? Italicized rather than underlined, followed by a comma. And we start with the volume number of the official reporter. So there's the volume, here's the official reporter, Win period space app period space, and then the page number on which the case begins, the page number on which the proposition is found, and I will call that a pinpoint site. Sometimes I'll call it a pin site. It's important, don't forget it. And then we have the parallel site, meaning the unofficial reporter, the Pacific reporter, and no pinpoint site is required. So you only have to cite the particular page of the official reporter. Finally, case year of issuance, and because this is a sentence, a period. Okay, write down any questions, bring them to class on Thursday. Okay, statutory citation. So the Blue Book is statutory citation is far more complicated than what will be than what the Washington style sheet tells us to do. So the Blue Book requires really 3 elements to a statutory citation. One is the reference to the code, the publisher of the code, and the year that the code was published. So you can see, for example, here we have the Consumer Credit Code of Oklahoma. So we got Oklahoma statutes. That's the name of the where the statutes are found, the reporter where the statutes are found, the section, and here the year. There's no publisher given because this is produced by the state of Oklahoma. You can see down here we have a Pennsylvania statute where it is the PA statutes, Pennsylvania statutes annotated is a West publication. You can find the way in which statutes, the way in which those statutes are reported and how those should be abbreviated in the same table that we were in before, the states and District of Columbia. Click through to Washington and it will tell you, oh, here's how we abbreviate those. So our official reporter, here's how it's abbreviated, section, year, and then if we were using West or if we were using Lexis. But the good news is that the style sheet tells us, number one, we abbreviate it just as RCW or RCWA, ARCW, but the style sheet really does want us to use the official reporter. Does not require any indication of publication unless there's something particular about that version that's being cited. There's no need to add the year, and there's no need to add wash. So the statutory citation looks very simple, like this. RCW 46, Title 61, Chapter 504, Section. Right, so here, in summary, RCW, not the Blue Book's abbreviation, no section mark, no year, and no need to use the West or Lexis site. Okay, whew, there you go. Might be a good time to take a break. I'm not going to take a break, but you should put this on pause and jot down your questions. Okay, let's talk about case briefing. Here's what I wanted to do. I wanted to cement some of what you did in your firms last week, and give you a sense of how I do it, and see if that's useful to you. All right, the picture here of rain boots has nothing to do with anything. I just thought it was cute. Okay, all right, so last time I gave you tips about case reading. The first thing I said was read it twice, right? Read it once all the way through, read it again, take some notes. Here I'm just giving you two pictures of the Smelter case with my notes and highlighting on them to point out what I'm trying to do when I take notes, which is to anticipate my brief and anticipate the fact that I'm going to want to know a few particular things. I'm going to want to know the facts, the holding, that I'm going to want to know if there are any general rules related to my statute. I want to know if there are specific rules related to the element that I know will be in dispute. And so you can see I've done sort of a combination of cryptic note-taking and highlighting, right? So here, the very first paragraph of the Smelter case gives you a pretty decent rundown of the procedural posture. And it comes back to it down here, right? And gives you a little bit more detail, telling you the case was tried in district court, was appealed to the Superior Court, and then again to the Court of Appeals. We've got a very concise statement of the facts, so I want to be able to find that again when I'm briefing. So I've given myself a little F with a circle around it to remind myself, here are the facts. And then down here, I see the court cited the statute, so I said, well, that's a general rule. It's the statute itself. Here we have I'm looking for the issue that the court is the particular issue the court's deciding here, which has to do with whether a defendant can be in physical control of an inoperable vehicle. So you can see as I go along, I'm extracting general rules, I'm looking at potential specific rules, and down here we've got those two big rules that Smelter announces. Okay. So then I'm thinking about taking some notes, but taking them in an organized and predictable fashion. And so when I'm talking about a case brief for as preparation, as part of your research, as preparation for writing, sort of the bridge to writing, I think it's important again to stop for a second and say, okay, this is a piece of writing. Who's the audience and what's the purpose? So the audience I would submit to you is you, right? These are notes for you to use to help you prepare the memo. It's not something you're sharing with your reader. It's not something you're sharing with me necessarily. And this does distinguish this kind of case brief from the case brief you're using in class. Again, the audience, well, maybe not. The audience there is also you, but the purpose of these two is slightly different, though overlapping for sure. And I think you can use the same format for that reason. But your purpose here is to help you to extract rules from the case, to also synthesize this case with other cases, to have an easy way to come back and say, okay, what happened in that case? How is that like this case? right? So your purpose is ultimately to use these to help you create, structure an analysis that will be helpful to your reader. You know, the purpose of a case brief for your classes is similar, right? So you may be called upon to describe the law in this area or to describe the the holding of this case, and you want to be able to do that in a clear and well-organized way. And the decisions don't always help you. So if you can organize it well, you're going to be 2 steps ahead. Okay, so for me, the contents of a case brief include these things. I generally start with the name. I put the site in there because I'm always happy that I did. It helps me later as I'm writing the brief to have the complete and accurate citation on my brief. And sometimes I put a little parenthetical just to remind me what this case was. Like, which one is this? And always has the facts. I usually bullet them. Always procedural posture to remind me how this case got to be before an appellate court. The issue, I try to reduce that just like the holding to a single sentence so I can and it is the issue related to my research, not every issue that was decided in the case. And then try to find the holding in the decision, but I generally am trying to relate it to the issue. You know, how did the court resolve the question that got presented in the issue? And the way I do this, though, some people flip it. Some people go analysis first, holding second. But here is really where I am looking for, okay, what did the court say in general about the statute? And what did the court say in general about the first element? Is there interpretation? Are there interpretations there that will be helpful to me? And then how did the court apply its holding or its analysis to our facts? Okay, that's what I include in the case brief. Here's what it looks like when I wanted to show you a nice template that I think you got in orientation, but I thought it was great because a case brief for class should generally include this little spot for case notes right alongside each of the elements I just went through. You can see that this person does everything I do, but they start with rules. What rules did the court announce? And then what holding did it come to? There's some logic to that. And what reasoning did it use to get there? Here's my brief. Not quite as beautiful, but here's State versus Smelter, right? And my little parenthetical is, I want to remember, this is the big case. Like, this is the seminal case. And I know it's a seminal case because the court in Maxey said so later. And so then I say, okay, what facts are important to this case? There it is. He was seated behind the wheel, car was stopped, vehicle was out of gas. Okay. We got the procedural history. I want to stop here just for 1 second to make sure to explain one concept that you will see over and over in these cases. And that is that they are tried by the district court as opposed to the superior court. So in Washington, the trial court in general is the superior court of, and they are divided by county, right? So there is a King County Superior Court, there's a Spokane County Superior Court. Those courts can delegate, if they have statutory authorization to do so, some of their cases to a court of limited jurisdiction. So often those are called district court or municipal court. And often the cases that get delegated to those inferior courts are misdemeanors. Our case is a misdemeanor. So you'll often see that it was tried before the district court, and that for that reason, the first appellate step is superior court, and then it goes to the Court of Appeals. Okay. And so you can see I set out the issue as best I can. I set out the holding, and then the meat of it for me is this kind of like, okay, how did the court get there? What rules did it announce? What rules might be helpful to me in my drafting of this memo, right? And then the last thing I'll do is to say, how did the court apply those rules to these facts? Okay. Okay, so there you are. So you're set. You're ready to get together with your firms, use your briefs, and argue the outcome of this case. So I've given you some instruction about that, but let me just say, again, I'm doing something a little bit artificial here, which is that I am forcing you to argue both positions, but based on one case only, right? So you are going to, in your firms, you're going to split into two groups generally of two, though some of you have a firm that's 3 people, so, 2 and 1. And you take, one group will take the position of the element is met, and the second group will take the position the element is not met. I want you in each group to make 2 different kinds of arguments. Make an argument based solely on the rules that are announced in that case. How did the court interpret the statutory requirement of actual physical control? And then separately make an argument based on analogy, right? How do the facts of this case, say Smeltzer, line up with our facts, and does that demand a particular outcome? And we'll use those arguments to kind of flesh this out, to understand fully what can be argued, and that will help us to make a prediction ultimately of what we think the court will do. All right, good luck, everybody. I wish that I got to have a conversation with you about this, but we will do that on Thursday. So do feel free, send me an email, send me a text, let me know if you have any questions. Okay, everybody, thanks.